Good morning. My name is Josh Blackman, and I am the president of the Harlan Institute. And it's my honor to welcome you to the 2020 Harlan Institute Virtual Supreme Court Competition. And this year, we're very proud to partner with Ashbrook, and I'm very happy to welcome Justice Brown, who will be one of our guest judges for today. Today, we are hearing the case of Torres versus Madrid. And we have team 8006 from New Jersey. And we have Rithika, please raise your hand. And we have Siddharth, please raise your hand. And then we have team 7860 from my home state of Texas. We have Brian, please raise your hand. We have Angela, please raise your hand. And I think we have everyone ready. Petitioners, please leave your cameras on. Respondents, please turn your camera off. And we'll begin our tournament. 10 minutes for the petitioners. We begin whenever you are ready. You proceed.
Thank you. Good morning, Your Honor. May it please the Court. On July 15, 2014, two police officers pursued a woman, Roxanne Torres, who had been using methamphetamine and was tripping out. The officers noticed her making furtive and aggressive movements and pursued Torres, while Torres, without the knowledge that these men were police officers, thought she was being carjacked. When Torres attempted to speed away, both officers fired their guns at her vehicle. In 2016, Torres sued both these police officers for violating her constitutional rights under the Fourth Amendment, claiming that the men used excessive force in seizing her. But the district court claimed that there was no seizure, therefore her rights were not violated. The U.S. Court of Appeals for the Tenth Circuit affirmed in 2019, stating that Torres was not seized by the officers' use of force because the gunshot did not restrain her freedom of movement.
Torres petitioned the Supreme Court for a writ of certiorari in 2019, to which the Supreme Court granted review. This case raises the question for the court: is an unsuccessful attempt to detain a suspect by use of physical force a seizure within the meaning of the Fourth Amendment, or must physical force be successful in detaining a suspect to constitute a seizure?
We, the petitioner, argue that an unsuccessful attempt to detain a suspect by use of physical force is a seizure within the meaning of the Fourth Amendment, for two reasons. First, using the doctrine of original intent, we can demonstrate that a seizure equates to a common law arrest, and the latter includes arrest in which the suspect escapes, therefore making Torres' arrest unconstitutional. Secondly, we prove that a respondent ruling on this case would contradict prior precedent, specifically the rulings in Hidari D. and Broward v. County of Inyo.
So if I could just jump in for a minute. You mentioned looking to the original intent of the Constitution. What sort of historical evidence do you find that supports your position?
So the historical evidence that we use specifically comes from the William and Mary Journal of Law, which talks about the original intent of writing the Constitution in 1776. And then we all...
Constitution was 1787. The Declaration was 76.
Oh, sorry, Your Honor.
Okay.
So yeah, so we look at kind of like the intent behind writing the Constitution in the first place. And then we also use just like previous precedent to establish stare decisis that we use further on in our speech.
Which specific historical sources are you looking at?
Specifically, we look at the Dictionary of the English Language by Samuel Johnson, written in 1755. We also look at the Bill of Rights Mary Journal, and we look at the Supreme Court's own decisions in the precedent we cite, specifically Hidari D., California v. Broward County of Inyo, and other cases that we mention later in our brief as well.
Okay. Well, maybe you can tell me a bit about the facts in Hidari D. What was going on there?
In Hidari D., the accused Hidari D., he claimed that he was seized under the Fourth Amendment and while he was carrying drugs. However, the other side claimed that he was not seized because the police officers that pursued him while he was carrying the drugs did not actually touch him or did not exert any physical force, and he was able to run away. Therefore, his arrest was not a seizure. And the Supreme Court did agree with that reasoning, concluding that because the suspect Hidari D did not get touched by a police officer or there was no physical force exerted on them, it was actually not unconstitutional and not an unconstitutional arrest. We use that to support our line of argumentation because Hidari D lays out definitions for an arrest for what constitutes physical force. And under those definitions, the use of gunshots, which was used in Torres v. Madrid, was a use of excessive physical force because it seriously endangered the movement of Torres, and it didn't allow her the freedom of liberty to move around, which restricted her physical space, which was an excessive use of force.
You may proceed with your argument.
Thank you, Your Honor. So our first main argument, which has already been briefly introduced by my co-counsel, is that a seizure is covered within common law. Since Torres's arrest would violate common law, it consequently violates the Constitution. As my co-counsel mentioned in the previous question, California v. Hidari was decided by the court looking towards common law. So the basis of this claim is rooted in three major lines of sub-argumentation. First, the definition of the Fourth Amendment. Second, the doctrine of original intent, which obligates us to use common law in deciding how we would define seizure. And third, any common law arrest is a seizure, therefore making the gunshots fired at Torres a seizure.
The Fourth Amendment to the Constitution reads, the right of the people to be...
I think Justice Brown's a question. Good.
What if the police had not applied the force to Torres's person, but only succeeded in applying force to her vehicle? Is that a seizure within the meaning of the Fourth Amendment, or is it only if the force is applied to the person?
Your Honor, we would argue that that it would still constitute a seizure for a couple of reasons. First of all, it restricts their liberty and restricts movement, which we think is the inherent nature of seizure in and of itself. And we will further establish that when we look at the William and Mary Journal further on in this speech. And because of that kind of line of argumentation, we think that limiting not just a person, but also a person's movement as a result of their connection with an extraneous object constitutes a restriction and thus a seizure.
So if they had shot her tires instead of hitting her person, that would be a seizure within the Fourth Amendment.
Yes, Your Honor.
Thank you.
Just to add on to that line of reasoning, according to the 10th Amendment's decision in Holland v. Harrington, the display of weapons and the pointing of firearms directly at people inescapably involves the immediate threat of deadly force. So in this specific case, Torres v. Madrid, there was gunshots fired at Torres, and that's why in the specific case, there was a use of excessive physical force, even though it didn't touch Torres.
Counselor, if I can ask a question, what are the consequences if we adopt your rule? In other words, how would your rule affect the ability of law enforcement to, try to keep us safe and protect society from harm?
We think there are a lot of great implications with siding with the petitioner, especially for law enforcement. So ultimately, we say that the application of common law rule promotes proper establishment of the Fourth Amendment and would allow law enforcement officers who lack valid justification to will be able to shoot or otherwise physically harm individuals with no constitutional accountability on the respondent side, so long as those individuals successfully escape the officer's violence. That result would significantly weaken the amendment's value in protecting individual liberty from unjustified government intrusions, therefore requiring the court issue a petitioner verdict in this case.
Okay, you may proceed.
Thank you, Your Honor.
The Fourth Amendment to the Constitution of the United States reads that the right of the people to be secure in their possessions and persons against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, describing the place to be searched and the people or things to be seized. The words search and seizure are quoted in the Fourth Amendment, both established to protect one's privacy under the Constitution. Since we assert that Torres was seized, this claim will naturally argue about the language established in the Fourth Amendment.
Furthermore,
By the way, I welcome Justice Sparks to the conference. He had a little technical difficulties, but we're ready to roll. So the petitioners are on their way now. If you have any questions, the petitioners, and you're on mute, sir.
Your Honor, may I proceed?
Yes, you may proceed. Okay. Justice Sparks, then you're on mute, so we can't hear you speaking.
Okay.
Counsel, proceed. We'll figure this out during the break.
Okay. So first, let's analyze the Supreme Court case California v. Hidari, which my co-counsel briefly touched on as well. The overall summary of the case, Hidari D., the defendant, dropped the drugs and he had been seized within the meaning of the Fourth Amendment. And to decide the case, the court looked to common law. So additional expert sources also confirm this interpretation that common law can be looked to when you're interpreting what seizure means in the context of the Fourth Amendment. Let's look at the William and Mary Bill of Rights Journal. It highlights that to understand the Supreme Court's current Fourth Amendment doctrine, it is critical to understand the common law. Therefore, we must look to common law in this case to define a seizure.
Any common law arrest is a seizure, therefore making the gunshots fired at Torres a seizure. This assertion is made since the sources collected by Hidari D. confirm that using common law, an arrest could be effected by the slightest physical contact. As we established with the 10th Amendment's decision in Holland v. Harrington, using a gun does constitute the slightest physical contact. The court elaborated on this definition of a common law arrest, stating that an officer effects a common law arrest of a person whom he has the authority to arrest by laying his hand on him for the purpose of arresting him, though he may not succeed in stopping and holding him.
To end this, we would want to look at the doctrine of original intent and historical sources to confirm this interpretation. Ultimately, because the Dictionary of the English Language and the William and Mary Journal correspond with our definition of seizure in common law, the petitioner rests its case and is proud.
Okay, thank you so much, Counselor. Justice Sparks, so can we get you off mute, see if we get your mic working? And I apologize if you lost a little bit of time. I'll give it back to you in rebuttal.
Okay, I think I'm cooking now. All right.
Okay, can you hear us?
Apologies to the participants. You can hear me all right?
Yes, loud and clear. All right.
Okay.
All right. Petitioner Siddharth and Rithika, thank you so much. You can turn your cameras off, please. Okay.
I have questions if you're ready. I don't know when you tell me. You lead the way, Josh.
I will. The respondents will have 15 minutes. They'll have about 2 minutes for their opening, and then we'll jump in, okay?
Okay, thanks.
Okay, respondents, 15 minutes, may begin.
May it please the court, my name is Brian Kang.
My name is Angela Nguyen.
And we represent the respondents, Janice Madrid and Richard Williamson in today's case. The issue before the court today is whether an unsuccessful attempt to detain a suspect by use of physical force is a seizure within the meaning of the Fourth Amendment, or whether physical force must be successful in detaining a suspect to constitute a seizure. On July 15th of 2014, the respondents came across Roxanne Torres, who was making aggressive movements inside the vehicle. The officers approached her in an attempted arrest, but she drove towards them, which made the officers shoot their firearms, as Roxanne clearly intended danger to the officers and potentially people in the streets. However, after she was shot, she drove approximately 75 miles to Grants, New Mexico. After the encounter, the petitioner was arrested on July 16th of 2014.
Your Honor, in our argument, we will address 3 points. 1, the 10th Circuit was correct in concluding that the petitioner was not seized for purposes of the Fourth Amendment. 2, the outcome of this case should not follow Hidari D. And 3, if this court does find that a seizure occurred, it must find that it is unreasonable to rule in favor of the petitioner. To address our first point, the 10th Circuit was correct in concluding that the petitioner was not seized for the purposes of the Fourth Amendment. Looking to Skinner v. Labor Executives, we see that it held that not every governmental interference with an individual's freedom of movement raises such constitutional concerns that there is a seizure of the person. The interaction between police and citizens does not always include a seizure. A seizure occurs only when the officer, by means of physical force or show of authority, has in some way restrained the liberty of a citizen. A seizure requires control rather than a mere touch contact, and otherwise it may be an arrest.
If I could just jump in for a minute, counsel, and ask a question, please. What is the best historical source you have that favors your definition of a seizure?
Well, Your Honor, as we look to Article 1, Section 6 of the Constitution itself, as it predates the Fourth Amendment and other sources that the petitioner has included, we see that it differentiates the seizure and arrest as it uses the direct word arrest. And as we see in the Fourth Amendment, there's no...
Article 1, Section 6, which provision are you referring to?
Oh, Your Honor, the exact quote in Section 1 or Article 1 of Section 6 is, "They shall in all cases except treason, felony, and breach of the peace be privileged from arrest during their attendance." And since this predates the Fourth Amendment and uses the exact word arrest, if the founding fathers and if the Constitution wanted to make arrest and seizure the same definition and mean the same, they would have used that in the future amendments that they made. However, since they differentiated those two words, the court has indeed differentiated seizure and arrest.
Okay, thank you.
Your Honor, in that line of thought, the analysis of a seizure has also been formed into a test called the Mendenhall Test in United States v. Mendenhall. The Mendenhall Test provides that police can be said to have seized an individual only if, in view of the totality of the circumstances, a reasonable person would have believed that they were not free to leave. This test was widely used in future cases, most notably California v. Hidari D, and provided a basis for determining when an individual has been seized in a certain incident. This test also takes into account the setting an individual is put in as described in Chesternut, and the 10th Circuit has successfully followed what has been held in Mendenhall.
Okay.
In the case,
Counselor, I mean, let's just talk about Hidari D. Didn't Hidari D resolve this case in favor of the petitioners?
Yes, Your Honor. However, the petitioner's use of Hidari is dicta, and there is a clear distinction and differentiation from Hidari D.
What is dicta, Counselor? Can you just help us out here?
Yes, Your Honor. Dicta is something that's used in a case that should not be used or be persuasive in other cases. The persuasiveness of a case should be the holding, and therefore we should follow the holding of Hidari. And there are clear differentiations between that case and our case. And that's three reasons. One is that it deals with physical force. Hidari dealt with a juvenile and police physically tackling Hidari. And the second is that the petitioner obviously uses dicta in the Hidari case. And three, that it deals with arrest. And in this case, it deals with seizure and arrest. And therefore, Hidari's outcome should be the only thing that be used in this case.
Thank you, Counselor. My colleagues have questions. You're welcome to jump in.
Okay, I want to talk about whether Tory's liberty was, you say that there wasn't any restraint there. One of the two shots paralyzed her arm. Before she was shot, she could use both arms. After she was shot, she was now only able to use one arm. She planned to go home. She had to change her purpose and her plan because of this interference. I mean, isn't that an interference with liberty when they're shot?
Well, Your Honor, as held in Brennan v. California, along with United States v. Smith, under the analysis, a seizure only occurs if the suspect actually submits to the police officer's use of force or assertion of authority. And again, mere physical contact by the officer is not enough to effectuate the seizure. And as our opposing counsel has brought up Broward v. County of Inyo, we see that this court held a Fourth Amendment seizure does not occur whenever there is a governmentally caused termination of an individual's freedom of movement, but only when there's a governmental termination of freedom of movement. In Broward, the petitioner's decedent, William James Caldwell, was killed when the stolen car he was driving crashed into a police roadblock. He had been driving at high speeds in an effort to elude the police when he crashed into the police roadblock created by an 18-wheel truck. These trucks were placed across both lanes of a highway and behind a blind curve so that Caldwell could not see it as he approached. The Ninth Circuit affirmed the dismissal of the petitioner's Fourth Amendment claim on the basis that no seizure had occurred.
Counselor, I have a question. The police in this case were clearly intending to seize her. They took some drastic steps to try and seize the petitioner. Why isn't that a seizure if they intended to seize her?
Well, Your Honor, even if the court does find that it is a seizure, the court must look further to hold that it is an unreasonable seizure to rule in favor of the petitioner. And with that analysis, we can look to the test set in Johnson v. Glick, the four-prong test, as 1, the necessity of the force applied, 2, the relationship between the need and the force, 3, the extent of the injury, and 4, whether the force was applied in good or bad faith. And with this test, we see the shooting was necessary in stopping Ms. Torres driving towards the officer, as they would have been put in harm. And the relationship between this need is proportional to the force, as the officers, again, were attempting to stop Ms. Torres before she became a threat to the community or to the officers themselves. Again, the extent of the injuries is not disproportionate as the petitioner was still able to drive off. And in fact, she drove 75 miles to a different city. And finally, the fourth prong is proven as the force was applied in good faith in an attempt for the officers to protect themselves and potentially others from the community from Ms. Torres.
Do you think that the court has to get into the unreasonableness question? I mean, I think that's for later consideration. I mean, the court's focusing on whether there's a seizure. If it finds there is a seizure, then the police officers may be able to nevertheless avoid liability because what they did was reasonable under the circumstances. Do you think that the court at this level has to get into the unreasonableness question to resolve this?
Yes, Your Honor. We believe that the court does have to get into the unreasonableness of the seizure. As stated in the Fourth Amendment, it clearly states that for the Fourth Amendment to be violated, there must be an unreasonable seizure within the home, within the workplace, or within a person. And the petitioner has the burden of proving that this was an unreasonable seizure. And it is important that we do get into the unreasonableness of the seizure presented in today's case.
Your
Do
Honor,
you think they have to get into the immunity question, the question of immunity of these officers? Do you think they have to get that far?
well, Your Honor, we're not necessarily looking at the unreasonable aspect to provide liability or such, but if this court does stop at only the seizure and not necessarily define or look into the reasonableness of the seizure, we see that it would create a dangerous precedent as letting any seizure be unconstitutional, and for this court to rule in favor of the petitioner just because a mere seizure occurred. For the Fourth Amendment does not only protect all searches and seizures, but it protects only unreasonable searches and seizures.
Do you think that the court should consider at all one of two questions or either of two questions, whether if they rule that there is a seizure or no seizure, let's say, they rule there's no seizure, Ms. Torrey's 1983 action is probably pretty much deflated. Should they consider that at all?
No. Yes. May I proceed, Your Honor?
I'm finished.
Your Honor, it's important that the court does factor the two questions as a whole. If the court were to rule in favor of the petitioner in today's case, it would set a dangerous precedent that in today's case, the officers fired 2 gunshots for their own safety and for the people in the streets. And if they were to rule in favor of the petitioner, it would even minimize the factor that they can enforce on an individual to stop the individual or even protect themselves. And the mere 2 bullets that were fired as being a seizure is would minimize how much of police action a police can have to seize a person.
Well, now you're talking about whether they should consider the effect of this on the police. Okay.
Yes, Your Honor.
You think that they should consider that in deciding whether this is a seizure or not? That is, how the consequences are going to play out if they decide one way or another. Do you think they should look to those consequences or not?
Yes, I think the court should look at all the circumstances and look at all the factors that are present in holding this case.
Additionally, Your Honor, as we analyze the reasonableness inquiry, we look to the precedent set in Graham v. O'Connor, and in this case, the court held that the calculus of reasonableness must embody allowance for the fact that police officers are often forced to make split-second judgments. However, this precedent alone, in ruling in favor of the respondent, we could see how it would create that dangerous standard for police officers to claim all of their judgments were split-second decisions. However, as a respondent, we also present the precedent set in Tennessee v. Garner, which held that police may not shoot at fleeing persons unless the officer reasonably believes that the individual poses a significant physical danger to the officers or others in the community.
Counsel, let me ask you a hypothetical question, please. Let's just change the facts of this case. In this case, the officers fired their guns. What if they had a roadblock? That is, in other words, they saw Mrs. Torres was driving down a road, and they had one of their associates put up those little roadblocks you see them on the side of the road, and she crashed into it. She wasn't able to swerve in time, right? Would that be a seizure? Because they didn't touch her; she touched them, right? They just put a roadblock in the middle of the road. She was flying down, and then she wrecked her car and crashed herself. Would that be a seizure in your view?
Yes, Your Honor, that would be a seizure. As we saw that in Broward v. County of Inyo, we see that they did create that police roadblock with the 18-wheel truck, and they placed it in a place where Caldwell could not necessarily see it as he took that blind turn, and it did stop him. And they ruled that in that case, that was the seizure part of.
So if that's a seizure where they didn't actually touch her, here they fired a bullet right at her. I mean, that's equivalent to touching her. How do you distinguish your facts here from the roadblock situation?
Your Honor, we distinguish the circumstances in these cases because the roadblock actually did restrict Caldwell's liberty of movement and such, because the police roadblock obviously killed Caldwell.
So, yes, okay, so I got you. I mean, but let's say that that the plaintiff here wasn't so strong. I mean, this woman was shot and she went on for 75 miles. I mean, I don't think I could pull that off, right? But let's just say they shot her and then she fell down. Would that be a seizure?
Yes, Your Honor. If she were to get shot and fall down and get arrested, that would be a seizure.
No. I didn't say get arrested. Just the second they shot her and she fell down, at that minute, would that be a seizure?
If her liberty is restrained by the police, then yes, Your Honor.
I mean, what kind of rule are we establishing? That means if you can shot and get back up, then you can't sue the police. But if you get shot and you can't and you stay down, you can sue the police. I mean, is it really how strong a person they can withstand a bullet? I mean, is that the rule you're wanting us to put forward?
Well, Your Honor, we're looking at the totality of the circumstances. As we see, the police officers didn't just fire at Ms. Torres for no reason, as we see that it is a reaction for her driving towards them, and the shots were in efforts to protect themselves and others in the community. And we see that with your analysis and with your hypothetical that there would be a seizure. However, we want to analyze this by a case-by-case basis, as you said before. And in our own case, she was able to drive that 75 miles to another city.
Okay. Counsel, you have 40 seconds left if you want to wrap up and give your conclusion.
Yes, Your Honor. We wanted to address the dictionary the opposing counsel used by Samuel Johnson in 1755. As the petitioner stated, the word arrest is defined using the word seizure. However, as we look at the definition of seizure in the same dictionary, there is no correlation between the two words. And again, even if the court finds that a seizure occurred, the petitioner must prove how it was an unreasonable seizure. And Your Honor, in conclusion, a seizure is different from an arrest, as it only occurs if the petitioner's liberty is restrained to where a reasonable person would have believed that they were not free to leave. Furthermore, the court must look at the totality of the circumstances as well as the surrounding the petitioner was in when analyzing the objective reasonableness of this case. It is for these reasons this court should affirm the decision of the 10th Circuit Court of Appeals in all respects and rule in favor of the respondents, Janice Madrid and Richard Williamson, in today's case.
Okay, thank you, Counselor.
Thank you.
Okay, 5 minutes for rebuttal for petitioners, please. And please, respondents, turn your cameras off, and petitioners, turn your camera back on. Okay, and you can be whenever ready. You have 5 minutes.
May it please the court. We will begin our substantive rebuttal of what the previous counsel has said by first just going in chronological order of their argumentations. First of all, the argumentation that the 10th Circuit was correct because not every government interference is restrictive and there's like seizure, which is applying physical force and authority. We fundamentally disagree with that statement for a couple of reasons. They back up the statement with the warrant that Article 1, Section 6 is the reasoning behind saying arrests and seizures are different. And we say that the contextualization of Article 1, Section 6 is for the U.S. House of Representatives and for the Senate. That's the type of people you're talking about in this case. I think we can all agree that Torres is not a member of Congress or legislative body, so the similar principle doesn't apply in this case as well. But in the event that this argument is bought, we say that the distinction between a seizure and arrest is actually an argument for our side. Because insofar as they don't differentiate between a seizure and arrest, since a seizure is different from an arrest, a seizure can happen when an arrest doesn't happen. So their own argumentation allows us significant amount of room to argue that.
If I could just jump in for a second. So one more time, what is the difference between a seizure and an arrest in your mind? I want you to just to draw that line for us if you can.
Definitely, Your Honor. So we use California v. Hidari and our dictionaries to prove that a seizure is when you attempt to restrict someone's physical liberties. And like that's done through physical force and the application or demonstration of physical force. And they use that definition themselves when they're talking about Broward v. County of Inyo and different cases that bring up, especially with the United States v. Smith case as well. So insofar as that definition we commonly agree on, and arrest is when you actually restrict someone's physical force by detaining them or by putting them behind bars without just an attempt to do so, that's the distinction we draw.
In this case,
Counselor, Counselor, I have a question. So when we're talking about just the simple meaning of the word seizure, if I fire a gun at a document, because the Fourth Amendment applies to papers and effects, that's not a seizure. So why is that? How does shooting a person accord with just the simple meaning of the word seizure?
well,
That
the
wouldn't
word,
apply to a document.
yes, Your Honor. The word seizure, again, it applies to restraining someone's freedom of movement, and that's one of their essential liberties. So by firing a gunshot at Torres, they paralyzed her and they restricted her liberty to move because she was obviously not free to go. The police were pursuing her. Additionally, as we mentioned in our case, according to the 10th Amendment decision in Hollington v. Harrington, firing a gun at someone is excessive physical force and it does seize them because it restrains their liberty to move. Just to add on, I want to provide a brief clarification to the case. According to the fact pattern and the case, Torres was not driving towards the police officer. She was driving away from them because she thought she was being carjacked, meaning that the police did not have significant cause except for being suspicious to fire their guns at her. She was not driving towards them. Additionally,
Before you get off, could you give a quick rebuttal to the question of dicta for the Hidari case, which you rely upon? Can you say something about that? Because that does bother me. It's not a holding there. The holding
certainly.
is, no seizure there.
Yeah, definitely, Your Honor. The respondent stated that we are using dicta. The first concern we have with this is they didn't actually mention anywhere where we are using dicta. They just said we are using dicta. It's kind of hard for us to rebut that claim without them near their specific place where they said we are using dicta. They just said we're using dicta. And furthermore, all the quotes we use from Hidari D are used by the court to determine what constitutes excessive physical contact. And that corresponded to their decision in Hidari D, because their decision directly related to whether Hidari was being seized. All the quotes we use are them defining a seizure and them defining excessive physical force, which are crucial to their case and this case by differentiating the seizures.
Furthermore, just to quickly clarify, obiter dictum in its usage in many cases refers to a judge's personal opinion or bias interfering within the case itself. So we fundamentally disagree with the definition also they provide you of just simply that it's not like properly defined, which is not correctly defined according to legal precedent of what obiter dictum is.
Okay, you have 15 seconds left. You can wrap up, Counselor.
The final thing we would like to state is the constitutional question provided by the Harlan Court is whether the attempt to detain a suspect is a seizure within the meaning of the Fourth Amendment, and the respondent actually conceded this in the questions. They said it was a seizure and we only have to prove unreasonableness. We did this in our case, and we actually answered the question provided by the Harlan Court, which is why we urge you to agree with the petitioner. Thank you very much.
Okay, thank you so much. Your time is up. Okay, this competition is now drawn to a close. If the respondents put their cameras on as well. Let me thank all of you. You've done a spectacular job. I can assure you, when I was in high school and I was your age, I could not have done this, not even close. I see my colleagues Ryan and John are shaking their heads. So this was fantastic. I think both teams did a really solid job. We hit you with some very hard questions. We hit you with some hypothetical questions that really don't have good answers. We asked you about historical sources. We asked you about cases, and you went back and forth. And I really appreciate how each team responded to the other team's arguments and did so respectfully, and not screaming, not yelling, not throwing bombs, but very respectfully. So I want to thank all of you sincerely. And I have hope for our future when I see young people like you do such a great job. John, Ryan, anything that you'd like to add?
Do any of you guys want to be attorneys someday or looking into that at all?
I'm actually looking into it, but I'm not sure what I want to do.
That's okay.
Well, you just, if you ever have questions, I'm sure Josh can give you my email, or
Happy to help.
be happy to answer any questions you have with brutal honesty.
Wait, do you want to talk about like your experiences?
Sure.
Oh, our experiences?
Yeah.
Sure.
Well, I think I probably have the least amount of experience of the justices here, but I work for a court, an appellate court in Ohio, and I help a judge draft all his opinions. And so we do a lot of reading of briefs, oral arguments, and writing opinions. And so I really enjoy the work. I enjoy it.
I I practice law in Pennsylvania and taught constitutional history at Grove City College for 38 years. So I agree with Josh. I'm very impressed with what you've done with this. And this case is really a toughie because it's a highly technical case. So you're not talking about some boozy ethical issue that you can have various sides on. It takes a lot of digging, and I know you've done that digging, and I appreciate your teachers too that I'm sure has worked with you on this, to turn out briefs like that and to make the argument in these difficult questions. So I hope some of you will practice and be involved in law practice.
And I'm a law professor in Houston, Texas. If any of you ever want to sit in on one of my con law classes, I'd be happy to have you in, just to ask your teacher, and I can make. It's really, I mean, classes are on Zoom. It's not very hard, so I'll just give you the link, and you're welcome to sit down on my First Amendment class. I'm teaching First Amendment this semester, Monday and Wednesday, 2:30 Eastern time, so 1:30 Central time. You're welcome to come sit in if you want to sit in. Just ask your teacher. I'll make it happen. Okay.
Can you send that to our advisor?
If you ask him, he'll get in touch with me. He'll make it happen. Okay.
Thank you.
He knows how to reach me. All right. Excellent. Thank you all so much. We'll be in touch with you probably around Monday with the scores. But that's all we have for now. So thank you. And you guys can disconnect.
Yep.
Judges, just stick around for a minute.
Okay.
And I'll stop the recording. Thanks, guys.
Thank you.
Thank you so
We
much.
just wanted to say thank you as well to all the judges and like our opposing counsel as well.
Oh, yes. Very gracious. Thank you so much.
Yes, thank you for setting this up, especially during this time. And yeah, opposing counsel too. Like it's early in the morning, so like thank you for a good round.
Yeah.
Very, very gracious. Thank you, guys. Thank you so much. All right. Take
Thank
care.
you.
Okay.